Let's first listen to Javier García Olmedo. I hope I pronounced it a bit correctly. He is a research fellow at the Max Planck Institute for International, European and Regulatory Procedural Law. Isn't that in Luxembourg?
That is in Luxembourg.
That is in Luxembourg. And you are as well an associate lecturer at Customary in London. So I was already wondering, you're traveling?
No, it's online and they launched a year ago. So I can teach from Luxembourg. We have a webinar session.
You teach online in London, but you are based in Luxembourg. That's it. Yes. So you are. You also have been practicing in the field of arbitration with various law firms, which are mentioned in the short CVs which are distributed, especially, let's mention them, Hogan, Lovells in Paris and Freshfields also in Paris. And also you worked as an assistant in the Essex court chambers in London for Professor Martin Hunter. So you have both the academic, and practice point of view. And you will speak about a very interesting topic and actually a very complex problem in practice, is that how do we deal with people with dual nationality in international investment arbitration? And that's typically a topic where there is no or not much written law, it's mostly customary international. So the floor is yours, and I have a PowerPoint. You have a PowerPoint, and you get all the things necessary for that.
Thanks and case for and the other organizers for having invited me, and thank you for especially having chosen this wonderful venue. When you go to conferences, at least in my experience, you tend to stand up in front of people, not surrounded by them, and this is indeed a very wonderful setup. So I really appreciate that choosing it. And what I will be discussing today is a very specific topic within the very broad spectrum of international investment law, and that is nationality, the nationality of the investor, and more particularly the standing of dual nationals under investment treaties. And when I say dual nationals, I refer to investors that have the nationality of both the claimant and the respondent state, well, the home and the host state, and not of the third state. It's an important distinction I have to make, because you can also consider a dual national as an investor that is a national of the home state and a third state, and not the host state. And so my presentation will be, well, what I will discuss in my presentation is first how customary international law regulates, or more accurately, deal with the international effects of nationality. And then I will discuss how investment tribunals have applied the rules that address the issue of dual nationality in customary international law in investment treaty arbitrations, and that will include the interpretation of nationality definitions in investment treaties, and also I will mention two cases in which investment tribunals have gone a step further and have tried to interpret customary international law on dual nationality, or at least that is the way I look at it. That is my view. So I will be very brief here. I'm sure you are all aware that under customary international law, a state is entitled to protect its national through diplomatic protection in cases where the individual is injured by international wrongful act committed by other states. And it is the bond of nationality between the state, the exposing state, and that individual that confers upon the state the right of diplomatic protection. Now, the question then comes, how do we define nationality? How do we define the nationality of the individual that would confer the exposing state the right to bring a claim on his or her behalf? And the international law, and the customary international law, to be more precise, there is a principle that it is for each state to determine who are their nationals in accordance with their own legislation. Now, another question that arises is whether that right is absolute. And there is another rule under customary international law that posits that even though the state has a right to determine who are the nationals in accordance with its own legislation, that right is not unlimited. So it means two things. The first is that the conferral of nationality under national law and also the invocation of nationality in the international plane may be denied in cases where those two elements, the conferral of nationality or the invocation of nationality, do not comply with rules of international law. And that means that we can have, for example, a nationality that was validly conferred, granted by national law, but it may not have international effect. It may not be opposable to the respondent state. So we are going too fast with the slides. At some point we can't go back. And there are two rules I would like to mention, two rules that have been recognized under customary international law and that were codified and will be seen by the International Law Commission in its draft articles on diplomatic protection. One of them is that in order for a state to bring a diplomatic protection case, the nationality of the individual must hold the nationality at two dates. And the first is the date when the injury occurred, the date when the host state, for example, adopted a measure in the case of arbitration, let's put an example, an expropriating investment. So at that date, the investor must be a national or the home state, the disposing state. And the other date is when the investor brings the claim. So as you can imagine, that those two dates don't need to be necessarily the same dates, can be different dates in time. And that is with respect to the timing of nationality. I hope you can keep that in mind because we're going to go fast now. And now, there is the other rule, customary international law, that applies to situations in which the individual holds the nationality of the claimant state and the respondent state, which is the topic of this presentation today. So there are two different rules that they complement each other. They don't exclude each other. So they coexist in parallel, we can say. You can see there at the bottom the two rules. One of them is the rule of non-responsibility of the state, which is based on the principles of equality, and the rule of dominant and effective nationality. Now, the first rule provides that an individual is not entitled to make his or her own state respondent before an international tribunal under any circumstances, regardless of more connections to the home or the host state. And the rule of dominant and effective nationality is a less restrictive rule. And it was intended to take into account developments in international law with respect to nationality. So the more individuals were acquiring more nationalities, they were doing business abroad. So that rule was created, let's say, to accord greater protection to individuals. And the interplay between the two rules was clearly stated by the US Italy Conciliation Commission in '55 in the merger case. I don't read the quotes, you can read it yourselves, but I want to just briefly, I included the quote there because it's important to highlight that the main rule is the rule of responsibility. You're not entitled to sue your own state. There is an exception to the rule, which is in cases which opens the door to claims of dual nationals, only in cases where the individual has more connections to his home state, that way making the claim international, let's say. And so the rule that each state, that states are entitled to protect its nationals, and that nationality is defined by national law of the sponsoring states, and also the rule, those two rules were already codified by the International Law Commission in draft articles on diplomatic protection, draft Article 4, and then the International Law Commission understood that the principal rule that would apply to dual nationality is not the rule of non-responsibility, but the rule of dominant and effective nationality. And that's why the Commission makes clear that the rule that would apply in those cases, again, is the rule of dominant and effective nationality. And if you can see there in draft Article 7, the dominant nationality has to be shown, or the individual must hold that nationality at the date of the injury and at the date of the official presentation of the claim. Again, codifying or reflecting the principle of the timing on nationality that I described now. So this is probably a big confusion, but it's a combination of all the rules that I just referred to above, customary international law. Oops. And so the rule of dominant and effective nationality and the rule of non-responsibility, they have been applied in parallel, more the rule of dominant and effective nationality in many cases in the context of diplomatic protection. And the first time, I think, unless I'm aware of, where a tribunal applied had to deal with the question of dual nationality outside the diplomatic protection system, meaning direct investigation dispute, was the Iran-US claim tribunals. I think we all know about that tribunal. And there were few cases in which the tribunal had to deal with the question whether a dual Iranian-US national was entitled to sue Iran under the Algiers Accords. And the Algiers Accords is a treaty, as we all know, and it contains a provision that it doesn't say like an investment treaty definition of investor, it simply says a national of Iran or the United States, as the case may be, means a natural person who is a citizen of Iran or the US. That's the only provision that we have in that treaty concerning nationality. And so the tribunal, there was an objection by Iran arguing, firstly, the rule of non-responsibility should apply, irrespective of dominance or effectiveness of the nationality. Says an individual, Iranian national should not be entitled to sue Iran under the deal's accords. But subsidiarily, Iran argued that if that principle, if the tribunal considers that principle doesn't apply, that rule doesn't apply, then it should apply the rule of dominant and effective nationality. Less restrictive, but still putting some limitations on the standing of dual national. Now, the tribunal very quickly referred to, well, it noticed that the treaty does not defines national, but it doesn't deal with the issue of dual nationality. So the tribunal had then to address that ambiguity. That's lacuna in the treaty, and the tribunal, in doing so, the tribunal referred to Article 31(3)(c) that we all know of the Vienna Convention, and decided and held that the rule that should apply in international law to fill that lacuna left in the treaty with respect to dual nationality was the rule of dominant and effective nationality. And the tribunal also held that if we will have another interpretation that no limitation should be imposed on claims of dual national, that will lead to an absurd result under the Vienna Convention, in the sense that it would mean that both nationals from the home and the host state can sue even both the state interchangeably, conveniently using both nationalities. Sorry, I'm going too fast, but 15 minutes is difficult to cover all I want to cover. So now we go into international investment law, investment treaties. How do investment treaties, how much do you have? Sorry?
5 minutes.
5 minutes? Okay. So how do treaties define nationality? We have the typical definition: investor must be a national of the home state in accordance with the law of that state. Some treaties contain the dominant and effective nationality that I described, and very few treaties contain the rule of non-responsibility. So I have included there a few examples. We can go back to that if you want in the discussion. And one of the very well-known treaties that contain the rule of non-responsibility is the Essex Convention. So the Essex Convention excludes jurisdiction in cases of dual nationality, and that rule is absolute. There is no exception to that rule. Sorry, I have to go very fast. But the question that arises: what happens in situations where an investor brings a claim under an international arbitration forum that is outside, that is not the Essex Convention, for example, antitrust? The antitrust rules do not relate to a nationality. The first case with that question, in which the tribunal faced that question, was the García and Venezuela dispute. And I have to make a very quick disclosure. I was counsel for Venezuela. Well, I was working for the law firm that represented Venezuela at the time, so my views may be tainted by that fact. But of course, my views are not do not reflect the views of Venezuela or the other party that I started working on in that case. So very briefly, the fact of that case: we have two dual nationals from Venezuela and Spain that were claiming against Venezuela under the Spain-Venezuela VAT, that doesn't restrict the nationality, contains a very broad definition of national. The investors had a very long-standing relationship with Venezuela. They were, of course, they were Venezuelan. They exercised the political rights. They were Venezuelan nationals. They made the investments by using and invoking their Venezuelan nationality, and many other factors links that connected them to Venezuela. And one of them, very important to mention, is that one of the investors at the time he made the investment, he wasn't a Spanish national. He wasn't a national of the home state. He was a national of Venezuela. So Venezuela objected jurisdiction, arguing very similarly to the arguments that were raised by Iran in the before the Iranian tribunals. The tribunal should apply the rule of non-responsibility, or subsidiarily the rule of dominant and effective nationality. And he also argued that there was no investment because at the time it was made, the investor didn't have the nationality of the home state, therefore the treaty would not apply. The majority of the tribunal rejected the objection, It went to interpret the definition of nationality under the VIT by referring to the Vienna Convention. And very briefly, the tribunal held that, well, first of all, it acknowledged that under customary international law, there is a rule of dominant and effective nationality and non-responsibility on cases doing nationality, but it refused to apply it because it held that it was a case, those rules are applied in the context of diplomatic protection. It didn't refer to the Armed Discipline Tribunal, so they cannot apply in investor-state arbitration. And then the tribunal applied, interestingly, the customary international rule, the timing on nationality. And it held that the investor must have the nationality of the home state, which is the only requirement, at the time of the breach and at the time of the presentation of the claim. And this is interesting if you take into account that the treaty does not define the timing of nationality. So the tribunal said we don't apply customary international law on the issue of nationality, but we apply customary international law on the timing of nationality. And then the tribunal concluded Article 31 of the Vienna Convention, ordinary meaning, if the treaty does not expressly exclude dual nationals, there is nothing we can do. It means that there is an implicit agreement by the state party to be sued by the other national. That's the conclusion that you can take from that decision. And then if I have 1 minute, I want to really discuss the dissenting opinion by Rodrigo Ramuno that is giving rise to our controversy today. Ramuno issued a dissenting opinion agreeing with Venezuela that the date at which the investment is made should be considered also a date to prove nationality. So then we have 3 dates: the date of investment is made, the date when the breach occurred, and the date when the claim is brought. And again, for me the question is this an extension of customary international law, because the treaty does not regulate the issue of time of nationality. But Ramuno agreed with Venezuela that date, the date of investment, is also an important date to consider. And that dissenting opinion was upheld by the Paris Court of Appeal very recently, which agreed with Ramuno that the date at which the investment is made should also be considered as the date of time of nationality. And then you have also the question, can national courts interpret customary international law? Can they actually intervene in BIT arbitration in that respect? And it seems that the French Court of Appeal did that. And last week, the week after last week, I think, it's in February, the French, there was an appeal before the French Cour de Cassation, and the French Cour de Cassation, the word was partially annulled on that point, but the French Cour de Cassation disagreed with the Paris Court of Appeal, but in the sense of the French Cour de Cassation held that the award should be annulled entirely, because if at the time when the investment is made is a condition for the investors to qualify as such, it touches upon the consent of the state it touches upon the consent of the state under the treaty. So the whole award should be annulled. And very last comment. Another, I think, interpretation of customary international law that relates to the dissenting opinion of Ramuno was made in the Valentine's Dominican Republic case, an answer to arbitration under the Central America Free Trade Agreement. And in that case, that agreement contains the rule of dominant and effective nationality. And the tribunal, but it doesn't define what is a dominant nationality. How can we determine the factors that will constitute a dominant nationality? And the customary international law, there's a case-by-case basis analysis, but it doesn't refer to investment in customary international law. However, that tribunal said that another factor that we should take into account, in addition to residence, economic ties, family ties, political exercise of rights, etc., it says that another factor should be the conduct of the investor at the time when the investment was made. So again, the question then arises was that tribunal also in a way interpreting customary international law, going a bit further than the actual test that applies in customary international law with the dominant and effective nationality test? And I think I'm done now.
I think otherwise I would take. Thank you very much for your.
We can discuss the.